Thank you all for coming today. For those of you who do not know me, I'm Helena Tavares Erickson, and I'm the Senior Vice President of the CPR Institute. CPR is a not-for-profit think tank and ADR service provider. I am on the CPR Institute side, which is the think tank side. And on behalf of CPR, I would like to welcome you today to our Africa Arbitration webinar series. The CPR Institute works through its member companies, law firms, neutrals, and members of academia to share best practices and develop innovative dispute management tools. Today, we are here to share best practices with respect to arbitration in Africa. We would like to thank our supporting organizations who have helped to make this webinar series possible. And today's program is specifically on terms of reference and jurisdictional challenges. I would like to introduce Tiwalde Ajaru, who is an accomplished legal practitioner, arbitrator, mediator, and management consultant. He is currently the managing partner of Olympus Solicitors and Advocates, and he works in complex commercial disputes as well as criminal matters. Tiwa has numerous degrees, including a law degree, a Master of Science in Management and Development of Financial Systems, an MBA, and a Master's of International and Commercial and Maritime Law. He is a member of several distinguished organizations, including CEDAR. He's a fellow of the Chartered Institute of Arbitrators and a member of the rosters of several institutes, including the London Court of International Arbitration. And he is also a member of numerous bar associations where he takes on a leading role. Tiwa, if you would take it from here. Thank you very much.
Thank you, Helena. Thank you for that. I welcome everybody to this webinar. This webinar, as Helena said, is on terms of reference and jurisdictional challenges in arbitral proceedings. I trust you are all doing well, and I thank both the audience and our speaker, Mrs. Adedoyin Rose-Vival, Senior Advocate of Nigeria, for taking out time for this webinar. I know for a fact this session will be very insightful and beneficial to us all. Today, I am pleased to introduce our speaker, a very distinguished, trailblazing, successful, seasoned arbitrator and litigator from Nigeria, Mrs. Adedoyin Rose-Vival, Senior Advocate of Nigeria. She is a British Sheridan scholar and the managing partner of Doyin Rose-Vival & Co. She is a chartered arbitrator and a fellow of the Chartered Institute of Arbitrators, UK. She is a past president of the Chartered Institute of Arbitrators, UK, Nigerian branch, and has over 4 decades of experience in commercial transactions, litigation, domestic and international arbitration. She has significant experience under the rules of major arbitral institutions and has been recognized by various publications, including Who is Who Legal Nigeria, GA Who's Who Legal, and Guide to the World's Leading Commercial Arbitration Experts. She is listed on the panel of various domestic, international, and domestic arbitration and ADR institutes. She has also been listed as one of Africa's 30 arbitration power lists. and as a distinguished arbitrator by Arbitrator Intelligence. She's on her second term as a member of the ICC International Court of Arbitration and a member of the ICC Commission on Arbitration and ADR. She is also a member of the panel of arbitration of the panel of arbitrators of the International Settlement of Investment Disputes, ICSID. She is a member of the World Bank Sanctions Board and has written several articles on arbitration and ADR and regularly delivers papers. She is also an approved tutor of the Chartered Institute of Arbitrators. It's good to have you here. Welcome, madam. Thank you.
Thank you very much, Tiwa. Just to mention that I'm not past president, but past chairman of the Nigerian branch of the Chartered Institute. Thank you.
Yes, the past chairman.
Yeah.
The role of the terms of reference in an official proceeding shall be dissected by our esteemed speaker, while the significant importance and ways of addressing issues around jurisdictional challenges will also be addressed in view of the fact that any lapse of judgment in respect of how jurisdictional challenges are handled can render the whole proceedings a nullity. Thus, it is essential for arbitrators to have a solid grasp of this concept. I kindly request you all to give your full attention as Mrs. Rosevival, Senior Advocate of Nigeria, guides us through the intricacies of these issues, while also pointing out avenues, laws, rules that can help arbitrators navigate these issues. The audience should also kindly note, if there are any questions during or after the session, kindly type them in your chat box, and the questions will be duly attended to by Mrs. Rosevival after the presentation. Kindly note this webinar will take the format of a question and answer style, and 15 minutes have been allocated for each of the issues under discourse, while 5 minutes have been allocated for questions in respect of each of the terms of discourse. Without further ado, I will commence with the questions, and I give the floor to our esteemed speaker. So, as stated, we will commence with our terms of reference, and I start now. Madam, we have just heard the role and the roles of CPR, the roles they play in dispute management. In view of this, can you give a brief overview of the role of arbitration in context of the CPR's mission?
Thank you very much, Tiwa, for that icebreaker question. I think the CPI has a great role to play in because I see the Institute is on dispute prevention and resolution. And this is so important in the context of how disputes are resolved and how disputes are managed. If I can just give an illustration of the first arbitral institution that we have, which is the Permanent Court of Arbitration, which was created as an institution to ensure that when disputes arise, people don't resolve disputes through the barrel of the gun, through arsenals, but through peaceful means. And that was why arbitration, that institution, was created as a means to helping states to resolve their disputes peacefully. So we can see that arbitration has long been recognized as a peaceful means of resolving disputes. Therefore, the CPR Institute does appreciate the fact that arbitration is one of the viable tools that they have in resolving disputes, in preventing them, because even now arbitral institutions are taking the stance that they should be more proactive in being client-centric, like that's a term used by the ICC court president, in being client-centric, looking to the needs of the clients. Do the clients want to be locked up in disputes? Do they want it resolved? What's the best way of resolving disputes? And in that respect, there's also other means. There's the mediation, conciliation, expert determination. I think the world has gotten to the stage that we have to begin to think of more innovative ways of resolving the disputes that are bound to arise. And then you can imagine the impact of this also on business disputes, on human lives, and so many factors. So that's what I like to say, that arbitration is a viable instrument to be used as a means of resolving disputes peacefully and without going to needless war.
Thank you for that, madam. Thank you for giving us a background of arbitration. And I'll now proceed to our next question. Can you kindly tell us the role of arbitral institutions?
Well, I'm sure that many of us here, I don't know, I might not know many of us here, but I know many of us will also be used to the system already. So some of these answers may seem elementary, and if it does seem elementary, I ask that you forgive me. But for the benefit of those that do not know, I think I have to answer that question, that there are different forms of arbitration. There's institutional arbitration and there's ad hoc arbitration. The role of institutions basically is that they provide support to the arbitral system in so many ways. And for instance, with respect to appointment of arbitrators, with respect to ensuring the way the process goes, with ensuring to even fees. In institutional arbitration, the arbitrator does not have to be concerned about how his fees are going to be paid. The institution takes care of all that. So the role of the institution basically is to provide support to the arbitral process. Whereas in ad hoc arbitration, the arbitrator is left on his own. He has to do all of these things on his own. I think that's just explaining it in a very, very simple manner. Their role encompasses various things: appointment of arbitrators, providing venues, transcription services, challenges, assisting with that. So that, in a nutshell, is really the difference between the two. One, you're on your own. Two, you have the support of a very experienced organization that knows what to do and when to do it. And they also help with the timelines. They help with the timelines. I mean, if you're in an arbitration process which is being administered by an institution, you know there are strict timelines. If they will tell you when they expect the award to come in, and they'll let you know that if you know that that award is not going to come in within the time frame in their rules, you have to apply for an extension before that time frame expires. So you can see that their role is basically support and training as well. I must mention training. And then importantly, they also give us guidelines. I'm always when I'm on my computer, I go to the websites of the various institutions I belong to see whether they have any current guidelines, whether they revise their guidelines. For instance, jurisdictional challenges, there are guidelines on the Chartered Institute of Arbitrators website. The ICC also has a lot of guidelines. They've done a lot of reports. So they're there as the guardian. Let me call them the guardian of the arbitration process pertaining to their institution, and to ensure that the system remains a viable way of resolving disputes. Does that answer your question?
Thank you, madam. Yes, very detailed. Thank you for that, madam. Going on to my third question. Madam, what is the relevance of the terms of reference in an arbitration proceeding?
Okay, thank you very much. Let me first of all mention that the term of reference, I think, is an innovation of institutions like the ICC, which a number of institutions have also copied now. Kigali KIAC also now has terms of reference. That's the Kigali International Arbitration Center. They also have that incorporated into their rules. Our own Lagos Court of Arbitration, that's also cited in Nigeria, also has terms of reference in their rules. Now, simply put, the term of reference is like a contractual document. It records the procedural steps, the procedural arrangements for the conduct of the proceedings. It also records various important key factors like jurisdiction. That's one of the things that will be recorded there. And jurisdiction is very important in arbitration. It will indicate the issues that are for determination. So it provides the framework for the arbitration. How are we proceeding? When are we going to have the hearing? Have the parties objected to jurisdiction? What are the issues in dispute? So it's a contractual document that provides the framework for the conduct of the arbitration. That's just in a nutshell.
Okay, thank you, madam. Thank you for that. Okay, proceeding to our next question. What are the items on the terms of reference? And can you kindly explain them? Even though I know you mentioned a bit while answering the previous question, madam.
Yes, okay. Now, the items on the terms of reference can be quite expansive. And if you, well, you know, arbitration is a creature of the contract of the parties. So to really, when I'm doing an arbitration and it's under a particular set of rules, I have my rules handy and with me all the time. I have an arbitration box where I keep my rules, where I keep my guidelines and anything I feel I may need during the proceedings. And if you look at the ICC rules or the CAC rules or the Lagos Court of Arbitration rules, it indicates what is expected to be in the terms of reference. And if you want a detailed indication, I've opened my ICC rules and it's talked about the names in full, description, address, and other contact details of each of the parties, their addresses, a summary of the parties' respective positions. Just a summary to be incorporated into that document. Unless the arbitral tribunal considers it inappropriate, a list of issues. So there's also flexibility there to indicate a list of issues. Of course, depending on how the case goes on, for instance, issues may change, parties may even decide on a different strategy to address their case. But at this present time, you also have to include the list of issues which the tribunal is supposed to be dealing with. That also helps because we all know the implications of a tribunal either not addressing all the issues the parties submitted to it, or the tribunal going beyond the issues that were submitted to it. So this is a checklist that also assists in keeping the tribunal on its toes to know exactly what is the ambit of what they are supposed to be doing in this reference. And of course, the place of the arbitration, we all know the importance of the place of the arbitration. We know the importance of the seat of the arbitration as distinct from the venue of the arbitration. And so those are the issues, those are the critical things that have to be incorporated into terms of reference. And if you check the rules, they're all there. The ICC rules have it, the CAC rules have it, the Lagos Court of Arbitration has it. But it's an innovation that was principally identified with the ICC Court of Arbitration, just like the scrutiny process that they put into place to ensure the quality of ICC awards. So I don't know whether you'd like me to say more, but it's really its key feature is to define the framework of the arbitration, and it's a contractual.
Okay, thank you, madam. I think you brought out the pertinent issues to that question. I would go on to the next question I have, madam.
Yes.
Can the terms of reference, can they modify the arbitration agreement? And if they can, to what extent? And if you can kindly give examples, if that's the case.
Well, you know, that's a very important question. Can the terms of reference modify the terms of an arbitration agreement? We all know that in arbitration, the parties derive their jurisdiction from the arbitration agreement. So the terms of reference on its own cannot modify the terms of that agreement. But then we also know that party autonomy is a fundamental principle in arbitration. So if the parties decide to exercise their autonomy and modify the arbitration agreement, no institution or arbitral tribunal is going to stop them, but it has to be done in accordance with the rules of the institution. So they cannot simply on its own modify the terms. It has to be done according to certain parameters and in accordance with the rules of the institution. For instance, you want to bring in new claims.
Okay, thank you, madam.
Yeah. I just wanted to add, if you wanted to bring in new claims, the most arbitration rules will provide for when you can bring in new claims. So you have to do it in accordance with what those arbitration rules indicate about bringing in new claims.
Okay, Okay, thank you. Thank you for fully dissecting the issue of the terms of reference, madam. At this stage, we really should proceed to the other item on the list, the jurisdictional challenges, but I would give the audience 5 minutes if there are any questions for our distinguished speaker. Anyway, while I wait for 5 minutes to see if there are any questions from the floor, I would ask my own personal question too. Can you say there are any cons of having a terms of reference in an arbitration proceeding? Any disadvantages with them?
For me, I don't see any disadvantage to it, because we must also understand that even where the arbitration procedure, let's say it's ad hoc, and it does, or the institution does not require terms of reference, even when we have our first procedural meeting, we record most of those things that are in the terms of reference in the first procedural order. They're recorded there. The advantage, even with its terms of reference, is that the parties sign. So when you sign, it becomes even it becomes an even more difficult document from a party to unilaterally say it's not what its understanding as regards the process was. So I don't see any disadvantage. I see it as something that establishes the framework for the arbitration. It's also even a very important, useful document. For instance, if there are matters, there are challenges before the courts, it can be a document that illustrates that the party who has filed the challenge has either filed a frivolous challenge, or even if the arbitral tribunal has not been as efficient as it should have been, because everything is recorded or should be recorded in their terms of reference. So it's a vital document, even during a proceeding in court. Apart from that, it's also useful when you are writing your award, I think, to ensure that you've dealt with what you're supposed to deal with, and you haven't gone outside the terms of your brief. Even in the ICC court, for me, it acts as a very useful tool during the scrutiny of the award, to ensure that you've dealt with everything.
Okay, madam. A question has actually just come in from the audience. It states that, is there any code for unification of institutional terms of reference across general arbitration practice?
Thank you for that question. I'm not aware of any code. What I know in the arbitration world is that the arbitration community have gotten together to do some standardized codes and guidelines. For instance, we have the guidelines on party representation. We have the IBA guidelines on rules of evidence, which arbitrators always use. But in regards standardizing the codes of reference, I've not come across any, but an examination of the ICC contents of the terms of reference, when you compare it with what the LCIA rules says about the terms of reference, and you compare with what the KIAC rule says about terms of reference, they are basically along the same lines. And apart from that, even when with the contents of your first procedural order would normally also be along the same lines. So there's no uniform code. It's a practice. And I think we should also be careful about having too many codes. Arbitration is meant to be a flexible procedure, and the guidelines are always very useful. A number of we arbitrators, we use them all the time. It ensures that even if you're coming from different legal systems, there's still a standard uniform way of perceiving what you are going to do and how you're going to do it. But with respect to a code with terms of reference, I don't believe there's one. And personally, I don't believe there's any need for a code for terms of reference.
Okay, thank you, madam. I'll just sneak in this last question, because it hasn't happened to me, but I've heard it has happened in certain situations. So agreeing to the terms of reference does that sometimes cause unnecessary delay to the proceedings? Has it ever happened to you like that before, madam?
It's never happened to me, but I know that at times you might have a party who does not want to sign the terms of reference. And I know that the current rules also provide for what happens. The ICC rules says that if a party doesn't sign, the court itself, the ICC, they can sign that. It can be submitted for approval, not that they can sign, it can be submitted for approval to the court. So that wouldn't delay the proceedings. But I think if it were to happen to me, I'll also make sure that I have complied with all due process rules or whatever. I would not just pass it immediately to the ICC secretariat. I'll make sure the party knows it's expected to sign it. I'll make sure it's properly documented that it's been asked to sign. I'll make sure it's documented that it does not include anything that was against what was decided during the proceedings or the discussions on the terms of reference. And if it did, I would record that party's views on it. So I'll just ensure I comply with all due process obligations and pass it to the secretariat. And if they give the party an opportunity to sign and it doesn't sign, it will be approved. So it won't delay. In my experience, other people might have different experience, but in my experience, I've always seen it as a positive benefit to the process.
Thank you, madam, for such an enlightening answer to that question. Thank you. We will now proceed to the jurisdictional challenges. In view of time, we won't be able to receive any more questions in respect of the terms of reference. So my first question, madam,
sorry,
under
Tiwa,
the item jurisdictional.
Yeah. I think I saw a question on the chat room about whether the TOR complements, whether the procedural order complements the terms of reference. I think I saw that question. So I don't know whether you want me to answer that or we,
Okay, please do. I didn't. Let me. Okay, it's just coming into my computer now.
Okay,
I didn't
yes.
load. So apologies to the audience for that and to the learned speaker. Considering the party's supremacy, what happens if there is a conflict between the terms of reference of parties and those of the institution?
I don't see why there should be a conflict between the terms of reference of the parties and the institution, because I'll explain to you how a terms of reference is finalized. It's between the parties and the arbitral tribunal. So it's what the parties have discussed with the arbitral tribunal and vice versa that's put in the terms of reference. It's just like when you have your preliminary meeting, the first preliminary meeting, and then you discuss certain things. And it's what is agreed that is then put in that terms of reference. So there's no issue of contradicting. The secretariat does not get involved with resolving the dispute. The secretariat is there as a support, and a very, very useful support at that. A very useful support, but they don't get involved in the dispute resolution itself. Just like the ICC scrutinizes award, but they do not interfere with the liberty of decision of the arbitral tribunal. They'll look at things like, we're all human beings. At times you can write an award, maybe your calculation is wrong, and they'll just call your attention to it. They don't tell you, they don't tell you what you're supposed to write in your award. That's your prerogative as the arbitral tribunal. So I don't know whether that has answered that question.
I hope that has answered the question, Mr. Thomas. Thank you. If not, you can always put a message on the group. We thank you for asking that question. Thank you. We proceed to jurisdictional challenges now. The first question under this item, can you please explain what a jurisdictional challenge is?
Okay, thank you very much. Jurisdictional challenge. We all know that arbitration is a creation of contract. Thus, the authority of the arbitral tribunal flows from that arbitration agreement, usually a creation of contract. There's some statutory arbitration, so forgive me. I'm not saying there's nothing like statutory arbitration. There is some statutory arbitration, but that's a different type of creature. But what we're talking about here is the arbitration as we normally practice it. Now, the authority of the arbitral tribunal flows from that agreement. And that's what makes it the agreement you have to look to. Even if you get a letter tomorrow and say, oh, Mr. Deroju, a dispute has arisen between A and B and would like to nominate you as the arbitrator, the first thing you look at is the arbitration contract. How do you know that in that arbitration agreement, the parties had not agreed that they wanted an engineer to resolve their dispute? And then if you go ahead and you accept that appointment, you've obviously gone beyond that arbitration agreement, and there's going to be a challenge. There could be a challenge not only with respect to your actions as an arbitrator, but even with respect to the subject matter. What if the arbitration agreement says that if any dispute arises in respect of defective works, that goes to an arbitral tribunal. But if there's a dispute relating to monetary payments or delayed invoices, that should go to the courts. And then without looking at the arbitration agreement, you go ahead and you assume jurisdiction and you start inviting the parties for a meeting. You've obviously gone beyond your jurisdiction. So that is really what a jurisdictional challenge is. But there are other types of challenges as well. For instance, there could be a challenge that the arbitration clause provided for resolution by mediation before going to arbitration. Now, if the respondent was to challenge that, it should challenge it on the basis of admissibility. It's not saying that you don't have jurisdiction, but the dispute is not admissible for you yet because the parties have not gone through the mediation process which they were obliged to go through. So the issues of jurisdiction flows from the arbitration agreement. It can also flow from the law of the arbitration, because the arbitration act will normally say that the act will not affect any provision in any law by which certain disputes cannot be submitted to arbitration. So obviously, if you go and, as an arbitrator, you go and assume jurisdiction in a criminal matter, you're actually going beyond the mandate that you could have. So that's really what the jurisdiction is all about, the power that the arbitral tribunal has, the authority of the arbitral tribunal, and it can only flow from the arbitration agreement.
Okay, thank you for that answer, Madam. You have succinctly explained it and also given us examples. Okay, thank you for that, Madam. Okay, my next question will be, at what stage do these challenges usually come, and when can it be raised?
Okay. At what stage does the challenge come and when can it be raised? First of all, as an arbitrator, I'm always, even if I think I know the answers to something, I'm always very mindful. My rules are always my Bible and the relevant arbitration law. So that's what I'll look into. What does it say? Most arbitration laws, including those based on the unilateral model law, talks about the need, refers to the need to always make sure that you raise such challenges on time. And it will normally be as soon as the matter which you consider not in accord, which you consider outside the arbitrator's jurisdiction having occurred, you have to raise it. You don't sit down and raise it. So most national laws, in particular, the rules provide that a party who wishes to challenge the arbitrator's jurisdiction should raise the challenge at the outset of the arbitration. As soon as you start the arbitration, raise that challenge. Raise that jurisdictional challenge if you knew about it at the outset. When you received your request for arbitration or your notice of arbitration, you raise it. And if it's not something that has occurred then, or the bar is not applicable at that stage, then you raise it immediately that matter happens. That is when you're supposed to raise your jurisdictional challenge. And if you look at the various arbitration rules is indicated there, the CAC rules, even our own Arbitration and Mediation Act, in the ICC rules, the LCIA rules, they're all very clear on when jurisdictional challenges should be raised.
Thank you for
Usually,
that, madam.
yeah, usually
Okay.
not later than when you are submitting your first response to your statement of defense. But if it's something that occurred later, then immediately you knew that something is not right here, then you raise that. You raise it as a jurisdictional question.
Okay. Okay. So as soon as you know about it, you
Yes.
raise it.
Yeah.
Okay. Okay. Thank you for that, madam. Is there any stage of the arbitration that parties are stopped from bringing jurisdictional challenges? And if there are there any exceptions?
If you most arbitration rules and arbitration law will put a time limit to when you're supposed to raise your jurisdictional objection. So if you raise it outside that time limit, then you could be barred. But in my experience, most rules also provide that a late objection could be considered depending on the circumstances of that lateness. So the arbitration will have some discretion on whether they should allow you even though you are late. But most arbitration rules and the applicable laws provide time limits. Maybe I think 30 days. It should be 30 days. But if it's something that had occurred before you were some bar, maybe this dispute is not the kind that we agreed to submit to arbitration, then you should raise that at the onset. You should raise it in your answer to the request for arbitration, if it's one in which request is, or in your response, whatever terminology is applicable in that instance.
Okay. Okay. Thank you. So at least we know that discretion comes into play if the circumstances warrant it. After
they warrant it, yes.
Yes.
But if they warrant it, I think the bar will be high. The bar will be very high.
Okay. Okay. Thank you for that. You've done justice to that. Thank you. My next question. I want to remind the audience that they can put their questions on the chat box so that this can be handled by our distinguished speaker at the end of this session. My next question is, who determines the jurisdictional challenge?
Thank you very much. Then I think I'll have to talk about the jurisprudential basis involved in this question. Now, the arbitral tribunal has the power to determine its jurisdiction under the institutional model law and under most, well, I won't say most, under modern arbitration statutes. The arbitration tribunal has the power to determine its jurisdiction. And its power to determine its jurisdiction, normally called competence, that means it's competent to determine its jurisdiction, flows from the principle that an arbitration clause in the contract is separate and distinct from the underlying agreement. Because if it were not so, if at the onset a party is saying the underlying agreement is not valid or it's void, then that party might as well say, well, since the agreement is not valid and not void, I'm not bound by the arbitration agreement. But because of the recognized principles of separability or recognized principles of separability of the arbitration clause from the underlying contract, then there's no room for that. So despite the fact that the agreement is no longer valid, the arbitration clause remains standing and valid. And because of that principle, that jurisprudential basis, the arbitral tribunal can determine its own jurisdiction. So first and foremost is the arbitral tribunal. Most national laws say it. Most arbitration rules say it. If it were not so, in fact, I don't think arbitration would be the effective process that it is today.
Okay. Thank you.
I don't know. Is that okay with you?
Yes, that has answered it. My next question will flow from that. Um, what factors are considered when the tribunal is dealing with these challenges? I know there are different types of challenges, but are there any particular factors that are considered?
Well, it depends on what the challenge is. If the challenge is that dispute is not one we agree to submit to arbitration, then the tribunal is going to look at the arbitration clause. And that's why it's always advisable to draft arbitration clauses very well. And I'd like to say at this stage that many of our institutions, they have standard model arbitration clauses in their rules booklet. I think we should always be guided by them, because if an arbitration clause is not properly drafted, when a dispute arises, you'll be surprised to find that that dispute was not one in which you had agreed to submit to arbitration. So it really depends on how your dispute is, your arbitration clause is crafted. So it really depends on the type of jurisdictional objection that has been submitted. If it's that the arbitral tribunal does not have the qualifications that was mandated under the contract, then the arbitral tribunal will be wanting to know what are the qualifications of this arbitrator and what was stated in the contract. If the party, the complaining party, is saying that this was not a dispute we agreed to submit to arbitration, then it's still the contract that is going to be looked at, or any other relevant law that is being relied upon by the complaining party. So it depends on the nature of the jurisdictional objection. But that arbitration clause is very, very important. Likewise, any applicable laws dealing with it.
Thank you so much, madam. I would go on to the next question, even though I noticed we skipped some questions, but we will come back to those questions in respect of the TOR at the end of the session. Apologies to the audience for that. Can an arbitration go on even if there is a jurisdictional challenge pending in the courts?
First of all, let me go back to what I was saying before. Even if an arbitral tribunal, just to lay the background that anybody who goes to court, or the party that goes to court, I'm not just saying for any flimsy reasons, a party that believes it has good grounds and goes to court after the arbitral tribunal has not considered its challenge favorably, can't do that because the arbitration rules say so. When the arbitration institution or the arbitral tribunal makes that determination, most of the rules still allow a party to go to court for the court to resolve that question. Now, whether the proceedings can go on whilst the matter is pending in court, I believe the rules also allows that. But if there's now an injunction restraining the arbitration from going on, then that arbitration should stop. I believe there's even a case recently where an arbitral tribunal went on despite a court order not to go on. It's not a Nigerian case, it's a foreign case.
Okay. Thank you.
But even in Nigeria, I mean, if a court order stops me from going on, I would stop. But if there's no court order stopping me, I'll go on. Even the rules allow me to go on, just like the rules allows a party to go to the court if he's not satisfied.
Okay. Are there, in your experience, are there instances that parties don't submit their challenge to the arbitral tribunal, which they're supposed to do, and just rush straight to the courts?
Well, if they do that, it will also depend on what is in the arbitration law. If the arbitration law says that the arbitral tribunal should determine that challenge, then they should come to the arbitral tribunal first. So if a party, anything can happen. A party can decide to behave in a very, in an inappropriate manner. The issue is how the arbitral tribunal goes on from there. The Act says that an arbitral tribunal can determine its own jurisdiction, so they should come to the arbitral tribunal for the determination of that question. If they go to the courts also know what the laws is, so the courts should know what to do with it and how to deal with it appropriately. Okay. But the arbitral tribunal, as far as I'm concerned, should carry on with its duty, make sure it invites the party to come before it, give them that due process expectation. We are having a preliminary meeting, make sure you come. Also make sure that whatever mail, in that kind of instance, even if we've been communicating through emails, I'll send a hard copy letter and I'll make sure it's signed, so that there's proof that he was given the opportunity to appear. And you know also what most of the arbitration laws, modern arbitration laws says, an arbitration tribunal can go on as long as that party has been given notice that there's a proceeding that it's expected to appear. If it doesn't come, you've given him notice, then that's that party's decision. But that should not stop the arbitral tribunal from going on and doing what it's supposed to do.
Okay.
It's all
Thank
due
you.
process.
Okay. Thank you so much for the clarity around that area. I know it usually brings a lot of confusion, but thank you for that. At this stage, I want to give, I would like to give the audience the floor to ask questions. I can say a couple of questions here, but there was a question from Mrs. Anishere, Senior Advocate of Nigeria. It says a question was kept on TOR for trying to get the question. Can she please send the question again? Okay, she's saying I skipped the question. How does an arbitrator? Okay, can you please send the question again, madam? As we wait on that, we'll go to the questions on the other questions on the chat box from SNA. If the arbitration clause is valid, but the underlying agreement is invalid under the law and has no effect, what is the value or use of the jurisdiction of the arbitral tribunal if none of the provisions of the underlying agreement can be enforced?
That will go to the merits of the case. That's a decision. I mean, is it the two parties that are saying the agreement is void? Surely not. It's one party that's saying it's void. And who determines whether it's void? It's not the party, it's the tribunal or the dispute resolution body that the parties have agreed. So that goes to the merits. So you start the proceedings, you file your defense. You file your claim, they file their defense. You have the hearing, or if it's documents only, and then the tribunal makes a determination as regards that. But that arbitration agreement is valid. The clause, the arbitration clause is valid. The agreement itself, for whatever it is, may be invalid, but it's not for the party to decide that. It's for the court or the neutral third party that they had agreed to decide that question. So it will be a question that goes to the merits of the case.
Okay. Thank you for that, madam. I'm sure that has clarified that issue. Okay. If not, any clarifications can still be put on the chat box. Okay, our next question from Mr. Nwadi, okay. Can the tribunal award costs against a party for an unsuccessful jurisdictional challenge?
Yes, a tribunal can do that. Because even if the party at the end of the day is the winning party, a tribunal can still do it. Because, I mean, the general principle is that costs follow the event. That means cost goes to the winning party. But the arbitral tribunal has a discretion in how it apportions costs. If a party has lost on a major point or on an application where considerable time and expense was spent, then costs can be awarded against that party. And that's why in arbitration proceedings, parties should be careful. I mean, they should not bring flimsy applications or bring overinflated claims. Because at the end of the day, it's all going to go towards the cost of the proceedings. It's not like in the court system, well, at least in Nigeria, the court system is not as robust as we'd like it to be, and maybe in some other countries too. Because if it were, people would be more careful about the kind of cases they institute in courts and clog up the court system. So even a winning party, yes, even a winning party can have costs awarded against them in an arbitration proceedings for maybe certain applications that they made and they lost on.
Thank you so much for that. I have noted the comments from Oki Kena about trying to get in the case where the tribunal went on despite an injunction from the courts. Institute will try and get this, and this will be communicated. I don't know if our esteemed speaker has that offhand, but if not, we'll get that to you. Yes. The last question, because time is fast spent. If the contract is invalid by statute as observed by the arbitrator, can the arbitration go on? This will be the last question, please.
If the contract is invalid by statute, for instance, if there's a reference and there's a law that says you cannot bring that kind of a matter, it's not arbitrable. We all know the principle of arbitrability. If it's not arbitrable, then I, as an arbitrator, would have ensured that I have jurisdiction before I even start inviting parties for a reference. Once I'm sure, for instance, if I'm a lawyer and I'm asked to resolve a dispute and the arbitration clause says it's an engineer, I'm not going to accept that appointment. Likewise, if I know that a dispute is not arbitrable and then there's attempt to appoint me as an arbitrator, I could deny outright or tell them to address me on that point just by letters that I observe that this dispute is respect of. It appears to me that, can I have your views? I could do that if I'm not really quite sure. But if I'm sure, I'll say, well, I cannot accept this appointment because the dispute is not even arbitrable. It depends. I could also ask the parties to brief me on it. Arbitration is a flexible procedure, and you can adopt procedures that best suits the case. Many arbitral institutions also have notes on conducting arbitration proceedings, on ensuring that you manage time and cost in arbitration proceedings. And I'll advise all of us to go to some of those websites. It's all on the website. ICC has very good notes on different aspects of the arbitration procedures. The Chartered Institute of Arbitrators has very good notes on different aspects. So I'll suggest that we always visit those websites, even if we are not members of those organizations.
Okay, thank you so much, madam, for the insights. That is very helpful. Thank you. Okay, the questions session is now closed. If there are any other questions, please send them through the chat box. They'll be recorded and you'll be responded to by email. I just want to clarify that the question from Mrs. Danisha, Senior Advocate of Nigeria, I'm trying to locate it. I haven't received any follow-up on that, but if it comes in before we close, it will be definitely addressed.
I think
so.
I want to.
Well, I have it for you. It's
okay.
Can we say that the terms of reference complements procedural order number 1?
Yes, I should think so because, yeah. Okay.
No, the floor is yours, madam. Yes.
Yes, I should think so. And attached to the terms of reference, you'll also put the procedural timetable. So with the terms of reference, although in other arbitrations, you'll have your procedural order number 1 and the timetable. But really, what's in procedural order number 1 is normally what is in the terms of reference. So with the terms of reference, you just attach your procedural timetable. Because if you now then do a procedural order number 1, your terms of reference, you're actually saying the same things. But if it's a proceeding that's not that does not use terms of reference, that's when we normally use the procedural number 1, and then we also attach a procedural timetable. So I don't know whether that answers your question, Mrs. Anishere. SAN.
So a second question, where the tribunal rules that it has jurisdiction, can a party still raise the issue of jurisdiction in its points of defense?
Where the party, but that if that is a matter that has already been decided by the arbitral tribunal, I'm just wondering why a party would still want to raise it on the same facts, or is it a new set of facts? So I'm just wondering why the party will want to raise it again. And we must remember that and not bring some certain habits into the arbitral system, because we find that, at least in my experience, I found that I can always tell the difference between a party, a counsel who's been involved in litigation, and a counsel who knows about arbitration. They conduct the proceedings in different ways. So I think we should always be careful of the kind of objections that we bring before an arbitral tribunal. Because whilst in the court system, you may not have to pay costs for such spurious objections that have no basis. In an arbitration proceeding, you will pay costs. And please also do remember that in arbitration, cost is cost. If a party has traveled, he's going to get his ticket costs. You are going to pay for transcription. You pay for transcription, you pay for the room, you pay for your flight ticket. So let's always be careful and continue to handle arbitration, or if we're arbitration practitioners, let's continue to handle it in the way arbitration was meant to be practiced, in a bid to ensure that there's appropriate dispute resolution and dispute prevention. Thank you.
Thank you, madam. That'll be all because our time is actually gone, and I can say Helena there prompted me. So I would have given a brief overview. I don't know if there's time for that.
He said yes.
For closing. Okay, yes. So to give a brief overview, we can see how the terms of reference can mar or shape an arbitral proceeding. It gives a framework which guides the procedure, and as such, particular attention should be paid to it, especially on issues surrounding formulation of issues. It is also crucial in managing time and ensuring a speedy arbitral process. We also saw how the intricacies and how best to address them in order as not to put the whole proceedings in jeopardy. Jurisdiction is the bedrock that gives the arbitrator authority to determine the dispute. I want to thank our speaker for systematically dissecting and analyzing all the issues brought up. Thank you so much, madam, for your time. Thank you to the audience. We appreciate the knowledge that has been imparted on all of us. I leave the floor to Helena to give closing remarks. Thank you.
Thank you to all who have attended today. We hope that you join us in the future for more of the Africa Arbitration webinar series. And we invite you also to join us for other CPR events. Beginning right now, our mediation committee is having an event on artificial intelligence in mediation. And you may find of interest an upcoming meeting of our diversity task force on June 26th at 12:15 Eastern Time. We are going to have a presentation on legislating diversity, how South Africa tackled the challenge of diversity in labor and employment arbitration. You can sign up for any of those events on our upcoming events page. And you can also find, to esteemed madam's point earlier, you can find comments as well as guidelines, protocols, and the like on CPR's procedures at drs.cpradr.org. Thank you all very much, and we look forward to welcoming you at an upcoming event.
Thank you. Thank you.